Morning. And in between cases, we'll have to take a quick break because Judge Myers will be coming in on our second case. The first case to be argued is the Brenda Moore versus Indian Hill case. And if the parties could come forward. Good morning.
I thought there was another party.
Yeah, I did too. Is there supposed to be another attorney?
Yes, mine is.
Mr. Maisland, we have this down for second.
Oh, okay.
But I don't know where he is.
Okay, then we can't proceed on this one. We might have to switch out, yeah. Sorry about that. Judge Bach was sitting in for Judge Myers today on this one, and
Can't vote for default judgment.
yeah, no, sorry. So we'll start instead with the Gauthier versus Gauthier case.
Yeah.
You can't, I guess you can't spring that on people. Okay, good morning. And who's going to be arguing for the appellant? Okay. Okay, and Mr. Grossman, would you like to reserve some time for rebuttal? 8 minutes? Okay. I'll keep your time, and then I'm also going to be using the lights. And when you have 1 minute left, it'll be, the yellow light will come on, and then the red light will come on when it's time to stop, okay? And whenever you're ready to go.
So I know that you've all read the briefs and seen that it's fully briefed to you. The basic argument is this, and our defense to the garnishment, and there's very limited defenses you can have to a garnishment proceeding. And our essential argument is that we have made payment. And the way in which payment was made is by paying the patent cost share of the appellee. And this is required by 7.E of the full text separation agreement, which was incorporated into a divorce decree, which is an order of the court. That order.
Mr. Grossman, may I interrupt you and ask a question
Yes,
that's
yes.
on my mind? If I understand your argument, would you agree that at any time that a party claimed to have a set-off to an amount owed, that they could argue that in a garnishment proceeding, and in other words, almost have a trial on that issue?
No, there's no, in this particular case, the garnishment argument is that we've made payment and it was pursuant to a court order. So we made the payment pursuant to a court order. In fact, we had to make the payment pursuant to a court order because 7.9B of the court order, which is the full text separation agreement, required that the patent costs be paid. And we paid them pursuant to that, and we had to pay her share because the appellee was not paying it.
But then isn't the appropriate remedy to get a court order, a judgment against her, and at that point then you could set it off?
We already have a court order.
A judgment. You have an order that says it needs to be paid. Your claim now is you paid it and she owes you under the contract. And
She doesn't owe us. We set it off.
Your claim is she owes you, that's why you set it off.
That's correct, and we had a court order that required us to pay it, and we did that. And we had to comply. If she wants to contest that, and now, obviously, you know that the appellee says that she disputes it, but she doesn't actually dispute it, because she doesn't dispute the legal requirement to do it. She doesn't dispute the amount. She doesn't dispute anything about it. She just says she has a dispute. And I'm saying that that's not sufficient. I'm saying that she had the duty to go forward with contesting it, and what she's really must be saying is that we breached by making the payment from the tax penalty reserve fund, which we did. We used it, indisputably, we used that fund to make her payment for her. And we told her we were doing it, and we had to do it according to the court order. So that's our point. Our point is that if in fact, if there was a requirement to reach some sort of other judgment, even though there was a court order already, I'm submitting that she had the burden of proof go forward with that. She had the burden to say that we violated the court order by using those funds, which we indisputably used. We indisputably used the tax penalty reserve fund to pay her share of patent costs. We did it because the court ordered us to do it. We complied with that. And I don't think that contracts are self-executing. She doesn't really dispute the contractual obligation to pay 50% of the patent costs. She doesn't dispute the fact that we invoiced her for it, that we told her what the amounts were. She gave us, all these costs, these are all invoiced by the United States Patent and Trademark Office. She was given all this evidence. She deposed my client on this point. All of the proof of the amounts that were owed, it's all been demonstrated. They don't dispute any of that. And all I'm saying is that we don't have to go into another judgment. We don't have to get another court order. How many court orders do we need to get to establish this? We were bound by a court order, the decree of divorce, which we've given you, that incorporates the full text separation agreement. And that, then we're in this terrible betwixt position, which we have to violate a court order, and then we have to challenge her and by violating the court order and then go back to get another judgment. This is not really, for me, justice is not a game. This is something where we actually paid this.
So the court order, the divorce decree court order is the one that addresses the patent costs, and who's required to pay? Was it your client required to pay all of it, or they both were?
Here's what it required. First off, in 7.5E, there was a fund that was established. That fund was depleted. Once that fund is depleted, what 7.5E of the full text separation agreement says, which is incorporated into an order of the court, the divorce decree, provides that you then share in those costs 50-50. Now we cannot, and this was her alimony, and under 7.9B, before any payments are made to her for the alimony, they must pay the patent costs in order to preserve, because this involved a portfolio of patents that were marital assets. And the only way in which she could get alimony is if that particular portfolio is maintained. If you lose, if you don't pay these patent costs, then the portfolio cannot be enforced. You cannot get licensing. You cannot get, enforce infringement rights. And she has no right then to obtain any alimony payments. We were required to ensure that that portfolio was paid. We're required to make sure that those patent costs are paid. And if we don't do that, then the entire rights are lost. And then she could have sued us and said, oh, well, you've lost my rights to alimony because you didn't do this.
Can you cite us to any case that says you can set off against a judgment, a certified judgment, an amount that has not yet been reduced to a judgment?
Well, it is reduced to a judgment because there was a divorce decree requiring us to make the payment for this precise amount for the unpaid patent costs, and we did pay them. And that's not disputed. That's my point, is there's no dispute about the fact that she owes 50%, and there's no dispute about the amount either. They just say that there's a dispute. But we actually established for them, and we did it in litigation with deposition, with invoices, and we did it because the divorce decree itself, which incorporates the full text separation agreement, specifies how we're to establish the amount owed. And we followed that court order. We provided that to her. And if she was going to say that we didn't do that correctly, I'm saying it was her burden to say that, not ours. I don't think we had to go into court once again to prove exactly what we did by following the court decree. And we followed the court decree. That's the whole point. And now for them to come in and say, oh, we've got to go get another judgment? We have to go into court and do this again when we already have it and we're complying with it?
You are at your time if you want to save 8 minutes.
Thank you so much.
Anybody else has questions?
Thank you.
Thank you.
Mr. Klingler, will you start where Mr. Grossman left off, and that is, why isn't he right that he already had a judgment that obligated his client to pay and your client to pay her portion, and why can't he set that off?
Well, he doesn't have a judgment.
Well, he has a court order,
Well, he has a divorce decree.
which
that-
is, would you agree that's a court order?
That's a court order. Nothing in the divorce decree reduces to a some certain, any alleged amount that my client Sue owes him. At the time of the divorce decree in 2009, it was assumed that the patent costs could be covered by the money that was already set aside in a fund, and that future patent litigation was going to bring significant funds to both of the parties. That hasn't happened. There's nothing of record that shows that the fund that was set aside initially has been depleted. There's nothing of record that shows how much my client Sue Gautier allegedly owes. There are invoices, but there's no reduction to a sum certain. So the court order that Mr. Grossman refers to is essentially a general order that says patent costs will be divided 50-50 between the parties. There's nothing that says how much that is. There's nothing that says how much has been paid.
Well, at the time the decree was written, nobody knew the amount, right?
That's true.
Okay.
No, that's true.
So the obligation is the parties would split everything 50-50 after the funds depleted.
That's what the divorce decree, the full text separation agreement indicates, yes.
And you are disputing that the fund is depleted, or you're just saying there's no evidence that it's depleted?
There's no evidence. There's no evidence in any court of record that it's been depleted. There's invoices, there's statements that I received from Mr. Grossman on behalf of Mr. Gautier that indicate that the fund's been depleted. But
Mr. Klingler, who prepared those invoices? Is it independent?
Mr. Gautier.
Okay, so it's not from an independent source.
Not that I'm aware of, no. The invoices that I got and that my client got from Mr. Gautier were all prepared by Mr. Gautier, and there's lots and lots of pages. I'd also like to point out Mr. Grossman's inaccurate when he says that, well, why should we go ahead and why should we have to get another judgment? They filed another claim in Warren County in 2018. The case we're here on today started in 2013 in Warren County, 2013. A counterclaim was never filed for these patent costs until months and years into the litigation. Mr. Grossman tried to file a counterclaim belatedly, and the judge at that time denied the motion to file the counterclaim. So what happened was, years later, the case is still going on, other cases in Warren County between these parties. In 2018, Mr. Grossman, on behalf of Forrest Gautier, filed another claim. We call it the 2018 claim up there to distinguish it from others. That claim does include these claims for patent costs. So that was being litigated.
Well, couldn't there be a contempt filing in the divorce case too? I mean,
Yes,
if
and
your
that was-
client's required to pay half and didn't, couldn't they file a contempt?
They could have, yeah,
Right.
they could have. That wasn't done. It was strictly a civil case in common pleas court that alleged that Sue Gautier owes half of these patent costs. We filed an answer denying that. We litigated it. And then last September 21st, Judge Teep in Warren County dismissed. We had a claim, they had a claim, dismissed both of them because he was tired, frankly, of cases, and dismissed them and without prejudice. Neither party has refiled. Mr. Grossman has not refiled. So as we stand here today, there's no claim in any court where Mr. Gautier is trying to establish how much Sue Gautier allegedly owes on these costs.
Let me ask you a practical question, because you're suggesting now that he needs to do that, and as you both have pointed out, this litigation between these two parties has gone on for an extensive period of time over several courts. Are you suggesting that he file another claim, reduce that to judgment, and then go through another garnishment, as opposed to establishing the amount of claim in the garnishment as a set-off?
He could have, well, I don't think, frankly, by the time we get to the garnishment stage, I think it's too late for him to try to establish a set-off of a claim that's never been litigated. What he could have done and should have done, in my view, is in the initial case, 2013, when we were arguing over who owes what, this tax penalty reserve was the initial one that he owed my client 50% of a tax penalty reserve. That claim, the counterclaim, the offset should have been filed there, but it wasn't. So we have no judicial finding, no finding of fact by anyone other than his client and Mr. Grossman, who claimed that, oh, this is what's owed, but we have nothing to substantiate at all how much, if anything, is actually owed. And we have defenses to his claim for patent costs that I think are beyond what we need to get into here. But it was not a simple case. It's complicated. There's a lot of issues. And he can't just, in my view, come in here and say, well, you know, she owes us this money. He can point to there is this order that says, as I said, 50%, but there's nothing that says how much that is. There's nothing to even say that, well, that really applies right now given the circumstances.
So what are these invoices? You're saying that he prepared them himself, and what kind of invoices?
The invoices that I've seen and that my client has seen are developed by Forrest Gauthier. They may have backups because we got hundreds of pages of backups supposedly from the patent office, but then...
Like bills or something?
Some kind of bill for patent costs, yes.
Okay.
But then we have a calculation or an accounting of some kind that Mr. Gauthier did that said, well, here's how much was in our fund, here's how much we've paid, so here's how much is left in the fund. Oh, now we're way below the fund, so we've never had a chance to test those invoices. We've never had a chance to challenge them.
Well, if you were given the opportunity, you know, if you were given the information about what was in the fund, the bills from the patent office, proof that he paid the bills, all of that, would this be appropriate for set-off in this case? So even if you had the opportunity to look at all of that, you're still saying that it's not appropriate?
I think that's right. I think there's an interesting legal question. This was supposed to be alimony for Sue Gauthier. The whole thing was supposed to result in something to her, alimony. That's what she bargained for in the full text separation agreement. Now we're in a situation where she allegedly owes hundreds of thousands of dollars to Forrest. She was supposed to get alimony, but now she allegedly owes him hundreds of thousands of dollars. So I think there's an interesting legal issue as to whether that is really what was contemplated in the divorce decree. But again, I think that's beyond what we need to get into here. The fact is there's nothing before the court that shows how much, if anything, she owes to him. And they could have done that. I don't know what the strategic reason is.
But you're saying even if they did that, it wouldn't have been appropriate to set off.
I'm saying we would have reserved legal arguments for whether or not that was even appropriate, even if the sums that they're claiming are all accurate, even if their accounting is accurate. My argument would have been it makes no sense for a woman who's supposed to be getting alimony in a divorce decree to now suddenly owe the husband hundreds of thousands of dollars. That was never contemplated. I don't know what the answer to that argument is.
Well, it was anticipated in the divorce, right?
It was not anticipated, in my view, Judge, in the divorce that Sue Gauthier might end up actually owing her husband hundreds of thousands of dollars on these patent costs. That was not contemplated.
Well, it was contemplated that there was a fund, that they were going to use the money from the fund to pay patent costs, right? And everybody knew how much money was in the fund at the time of the divorce.
Yes.
And they knew that if the patent costs were more than that, then the parties would have to split them 50-50.
That would have been a logical conclusion from reading the decree. I agree. My point is that nobody, certainly my client, I don't think Mr. Gauthier, anticipated that as a matter of fact, she might owe him money.
That it would be, that the fund would be depleted, basically.
Correct.
No one anticipated the high cost of these patent.
That's true. And the only reason she, and I was not her attorney at the time during the divorce, but the only reason she would have, in my view, agreed to pay half the patent costs is because everybody thought that's going to be a great deal because we're going to make a lot of money on this patent litigation, which has not thus far turned out to be true. And I can't get full information at this point as to exactly what the status of those cases are, but my understanding is that most of them have been lost at the summary judgment stage. So I don't know how much, if any, more money is coming in. But I do know that certainly my client, I don't think any of the parties anticipated that instead of getting alimony, she's going to end up owing him hundreds of thousands of dollars.
But even if she didn't anticipate it, I mean, this was a contract in the divorce proceeding or the divorce decree, she understood that potentially she could owe additional money.
I don't think she ever understood, Judge, that she might owe more money than the alimony that she expected to get. Okay. I certainly cannot say that she anticipated that, and there's nothing of record to indicate that. And again, there's nothing of record to indicate how much, if anything, my client owes Mr. Gauthier. That's something that a court needs to decide, divorce decree or no divorce decree. There's no numbers, there's no nothing, there's no basis on which this court or any other court at this point can say, oh yes, she owes him money, let alone how much.
Would you agree that if the judge had not dismissed the claim without prejudice, but had rather rendered an order that said she owes him $50,000, that then Mr. Grossman could have offset that amount in the garnishment proceeding?
Yes, absolutely. And in some ways it was a rush for a while. It seemed like it might be a rush to see which court was going to make a decision. But as I said, that case was dismissed last fall. For whatever reason, they've never, well, I think this case had already, the garnishment had already happened by that point, but it was too late. But they've never refiled. If they could come into this court today and say, we have a $50,000 judgment, I'm not sure that would make any difference at this stage for this court. They can go try to collect their judgment like we had to collect our judgment against Mr. Gauthier. But we don't have anything like that here. We just have a garnishment. We have a valid judgment, no offsetting judgment. We have a valid garnishment. The amount has been collected. It's been paid. The case is over. It's that simple in my view.
Have the funds been dispersed?
Yes.
Is this case moot?
Well, I think it is. I guess the purpose of this appeal is to get to reverse. I don't know what happens if it's reversed.
Well, would you agree if we cannot give the remedy requested that the case is moot and that we should dismiss the appeal?
I agree. I think that's where we're at. I don't know what else could happen.
Is it in our record that the amounts have been dispersed? Or are you telling us that outside of our record?
There's an order, I believe Judge Heekin signed to Mr. Hunt, the garnishee, to disperse the funds.
But do we have anything in our record that they have been dispersed?
Yes, as a matter of fact, Judge, now that you're mentioning it, there's a satisfaction of judgment of record. So our judgment has been satisfied in this case.
Thank you.
Thank you.
Mr. Grossman, I'm going to ask you to start where I ended up with Mr. Klingler. What
where I was gonna
remedy
go.
could we possibly give you if the funds are gone?
Well, first off, the mootness would only be the case if the funds were paid voluntarily. And we actually briefed this question to you June last year because I believe you, Judge Myers, requested that we brief it.
At least I'm consistent.
You are, and you've always been that way. But the fact is, we briefed this very question, and then you agreed that the appeal was not moot. And the reason for that is we, of course, immediately moved for a stay in front of Judge Heekin. He denied the stay. Then we immediately moved for a stay in front of this panel. And we pointed out that the funds were all in escrow. and they were all there. And of course, you're automatically, entitled to a stay if you have the funds. And we were offering to have, the escrow was offering to have them paid into the court as well. So there would never have been an issue about that. And there was an escrow agreement that he was not to disperse the funds unless there's a court order. But that escrow agent was then cited with contempt. And even though the escrow agreement was that they were not to disperse funds until there was a final decision, they did, contrary to our escrow agreement. So all I'm saying with regard, have they, said that the thing has been satisfied? They have. It's not in the record of this court, but they have said that. And the funds were dispersed by the escrow agent because of the threat of contempt, contrary to our agreement and over our objection. So I don't believe, for the very reasons that we addressed to you with regard to whether there was still jurisdiction and whether it was moot, that's my argument to that. And I hope that that's okay, but if we lose this, we lose it on that point. I don't think that we should, because it was paid under compulsion, contrary to the escrow agreement, by the escrow agent who was being threatened with contempt. And we asked for an expedited hearing, as you may recall, before this court on the stay motion precisely for this problem, which the court denied. And as a result of that, that's what happened. And we did everything possible for us to deal with it. The funds were in the escrow. They were there. They were holding them. They would have paid them into court. Then we would have automatically had a right to a stay. And that just didn't occur as hard as we worked on it. Going back to, may I go back to?
Yeah, go back to the merits, because what I'm really interested in is, isn't there a step missing? And that is, there isn't a court determination of amount to be set off. And at the garnishment hearing, that's not the purpose of a garnishment hearing, is to have a trial.
We followed the court decree again, and they're not telling you about this. The court decree establishes how we're to establish the amount. And we complied with that. And it said we're to do it by giving them a summary memorandum of the amount that's owed with regard to any proceeding, and we did precisely that. And we did more than that, because we gave them the invoices from the Patent and Trademark Office. We gave them and submitted to a deposition on this where we set those amounts out specifically, not merely in a summary fashion, which is what the court decree provided for. We did way more than that. So we followed the court decree, we gave them the amount, and we went way beyond that, because we gave them, not merely was it just an invoice from our client, which is what the court decree says as well, but we also gave them all the backup information and the invoice from the Patent and Trademark Office.
And that was in connection with the claim that was then pending in Warren County that the judge, no?
Nope, that was not how it happened.
The deposition was?
It was, that was pursuant to a different matter. And so there were multiple matters going on, but we agreed to submit to a deposition ultimately, and that deposition was taken. And and there are many matters that were going on here, but what the court never decided was the question of the amount that was owed. That's true, the court never decided it, but it doesn't have to decide it, because the way in which this is determined was already set forth in the court decree, and we abided by that. That's my whole point, is that we actually have complied with the decree, and we would have been in violation of a court order had we not done this.
Did you provide proof that the fund was depleted?
Yes, and we did that as well, and we did it with documentation to them with the Patent and Trademark Office's invoices. We went above and beyond the decree, which was a court order that we had to comply with. And then we told them this. You see, they're not telling you that they're saying they dispute something, but they don't really. You notice how they said, oh, well, there was some other legal dispute? Well, what would it be? Because, Judge Krause, they anticipated that there was going to be a depletion, maybe. That's why they agreed that if there was a depletion, they would pay 50% more. It wasn't that...
Could you seek a contempt motion in the divorce case for her not paying her half percent?
Well, not for this amount, because we already paid for it. We could never have established a contempt for something that she already paid. That would have been completely inappropriate for us to charge her with contempt for an amount that we set off properly.
Oh, you're saying you set it off so you couldn't ask for
So we couldn't do that. We could do it. We did it with regard to amounts that were not set off. That's true. We could do that, but we couldn't do it for something that we did. So my point is, they had to claim that we breached by using that amount to set off, which we did pursuant to a court order. You know, I've maybe gotten too close to this case. It's been too long, so I'm sorry that I'm a bit emotional about it. Because my client, you know, he paid hundreds of thousands of dollars an hour. You know how they said, oh, she would, and $750,000, there's been tons of money paid to her. And the fact of the matter is, and it's set forth in the addendum agreement, of $750,000 were paid to her, which were paid in large part from patent litigation that they did. And she's paid way more than the $50-some thousand that's the set-off. So we could not file a motion for contempt. We complied with the court order expressly, and we were ordered to do it, and we did do that. So, and we gave them, and the court order also explains how we're to establish these amounts. And we followed that court order, which says we are supposed to give them a summary memorandum with regard to how these amounts work, and we did that, but we did more than that in this case. We also provided her with all of the bills from the Patent and Trademark Office, all of the invoices from that office, and it was supplied to them by multiple times by letters, and it was subjected to an examination and a deposition where they examined all this material. They specifically went through all of it with them. They told you that they didn't have the opportunity to do that. Oh yeah, they did. And they don't. And then when they came back to us and we said, here's what we've done, because yeah, she if you didn't set it off, she had like $270,000. We set it off. And then ultimately there were some other adjustments because there was some other patent litigation where we got a recovery. And we gave her the benefit of that. And we gave her the information that the divorce decree requires us. So when he says he doesn't know, oh no, he knows everything.
You are at your time.
Thank you.
Unless there's other questions?
Thanks so much. Appreciate it.
Thank you.
Thank you for your arguments. We'll take the case under submission and issue a timely decision. The next case on the docket is Brenda Moore versus Indian Hill. The parties could come forward, please. Good morning. I don't know where you
You
want
have
to
to sit with
sit.
somebody. Mr. Roberts, you can choose
Pick a table.
who you want to sit.
You can sit over at this one if you want to sit at your own table.
I'll be standing.
Right. So you all received our order of how we're going to proceed. We're going to start with the cons, and that is, who's going to be arguing?
Blake Maisland for the, cons for the, I guess it's the
Okay. Okay. And then our other appellant is the Brenda Moores. Okay. And then we also have Indian Hill.
Scott Phillips on behalf of the village.
Okay. And so for the cons and the Brenda Moores, you both are, you have cross appeal, so you can reserve some time for a rebuttal. How much time, Mr. Mason, would you like?
3 minutes.
3 minutes. And for the Brenda Moores? 5 minutes, okay. I'll keep your time. I'll try to keep your time and use the lights on the podium. So, Mr. Mason, whenever you're ready.
Guys, first let me just apologize. It was a very difficult morning, but I did get here. I don't have any of my things with me. It was part of my hang-up this morning. Feel free. I think everything that I'm going to mention is spelled out in great detail in the written briefs that have already been submitted with the court. And with that, let me just give you a little bit of history. I know the cons, their family, friends. They came to me with this case after years and years of frustration of trying to build a new home in Indian Hill. By way of history, the lot that the cons were trying to build on was the Tuttle property. The Tuttles, Brenda Moores, and Indian Hill all contracted to divide this lot. Part of the lot ended up being sold to the Kahns, and now the Kahns want to build a house. I think it's super important for us to realize and to remember and to recognize that the Brendamores were always a part of this contract. And part of this contract said that the lot that the Kahns ended up purchasing is not an illegal lot, and you're not allowed to call it an illegal lot, and you're not allowed to challenge it to be an illegal lot regarding the frontage of the lot, because everybody knew when they divided it, including the Brendamores, that there wasn't going to be enough frontage for this lot. But when the Kahns purchased this property, which was subject to that contract, which ran with the land, then they ran into problems when they presented their first plan, their second plan, or any plan to the Indian Hill Commission to try to build their house.
But the Brendamores weren't contesting the frontage of the lot, were they? They were contesting
sure.
the rear portion.
No, actually, Your Honor, most respectfully, they were arguing against all portions of that lot. They created situations where the Kahns could never have built. They argued about the rear, but then they also argued about the front, and they argued about the address, and they argued about the front all the way. And specifically, the only thing that would have made that lot a quote-unquote illegal lot would be the front setback. And it wasn't just the Brendamores that made this argument. The Brendamores went and whipped up all the people in the neighborhood to sign a petition to say that it was an illegal lot.
Let me ask you, Mr. Maislin, I'm looking at the contract, and it indicates that, as you said, discusses the lot frontage, but part of it says it must otherwise conform to the village zoning ordinance. And if my recollection and understanding that it was the size of the house as well as its closeness to the Brendamore property, among other things, that was opposed. Am I correct in that?
Correct in that it was opposed along with the setback line, but respectfully incorrect because this court held that that plan finally was in fact conforming to all the Indian Hill codes. So they argued a lot of things, but within that argument was the improper setback. But was it?
But the contract doesn't prohibit the Brendamores from contesting the construction of the home. If just throw out the lot, the frontage on Holly Hill. I mean, if they tried to build an apartment building on that property, or I don't know, a steel plant. Are you saying this contract prohibits them from opposing?
Not at all.
Okay.
Not at all. And what I'm saying is, if there was actually something else wrong with the lot, then yes, then they can proceed with that. And if they win, then they were also allowed to argue the setback. Understand?
I thought that's what they did. I guess I'm not understanding. I thought that they were contesting the rear part of the rear line. Like that was the main issue.
No, they were contesting the front line and the rear line. So if you notice, even in their argument originally to Indian Hill, if you read it closely, they talk about the rear line setback. But once they fail in their argument for the rear line setback, then they resort to the front line setback. And the same thing in the reverse. They argue about the front line setback, and then when that fails, then they argue about the rear line setback. And I guess what I'm saying is, the contract says you can't argue that this is an illegal lot unless there's something else wrong with the lot.
So they couldn't just argue on the front line. That would be prohibited.
I'm saying
that it's illegal because of the frontage.
Correct.
But if they argue that it's illegal because of the rear line, then they can argue the rear line and the front.
I don't agree with that.
They could only argue the rear line then?
Correct.
Okay.
And if they are correct, so understand what the contract says. It doesn't say that you can argue everything, and as long as you argue everything, you can argue against the front lot setback.
But if they only argued the rear line, you're saying that they also argued the frontage?
Yes.
I think they dispute that, right?
Yes.
They're disputing that. They're saying we just argued the rear line.
I mean, I think
but you agree they could do that. They can argue about the rear line
Yes.
under this contract.
Yes.
Okay.
Mr. Maislin, if I'm understanding you correctly, you're saying that if they argued about the rear line or the size of the house or anything else along with the frontage, you're saying that they're not permitted to do that?
I'm saying that all the other arguments are see-through, they're hollow. There was no basis for any of that. And they they started out by arguing the front line setbacks. They got everybody whipped up in the whole community to say that it was an illegal lot based on the front line setbacks. At some point, they begin to lose that argument and switch gears and go through a transparent, hollow argument all the way through the rest of the case that there must be something other wrong with the property, whether it's the address or whether it's the rear line setback. But understand, those are hollow. And when you take hollow arguments and you put them with the front line the only reason why the front line setback was in that contract was because it was the only argument that ever had merit. The rest of them never really had merit. And they just tagged them along. And as this court held, none of those other arguments indeed had merit. They lost all of it.
Well, didn't they win at one level, at magistrate, or?
They did. They did. They won a magistrate's level.
So a magistrate agreed with them.
They did. In one of their several appeals, they did have a ruling in their favor. But ultimately, remember what the contract says. It says you can't argue the front line setback unless the property is otherwise improper, otherwise a violation of the code. We know, as a matter of law, that there was nothing wrong with this property other than rear line setback.
But that wasn't determined until well after the events took place.
That's true. Well, that's true. But it still relates back. You know, the other thing is, if we're going to say, okay, well, they were allowed to argue rear and they were allowed to argue front, then I would say that discovery at least is needed so that I can go back to the attorney that was arguing all these things and say, well, what were the arguments for the front line setback? Because there were arguments and briefs and hearings based on the front line setback. And, you know, remember, this is the motion to dismiss. So all the complaint has to do is state a claim upon which relief can be granted. And clearly all that language is in there. I mean, it's very well detailed, it's very well written. If the defense is going to be, oh, well, they argued other things, if nothing else, we should at least get discovery done so that we can earmark what were the damages specifically related to frontline setback. And I think you're going to see that it's the majority of the defense in this case.
So are you saying that the other arguments about the rear line, are you saying that they just made those up so that they could argue the frontage?
Yes. Yes. I think they're completely transparent and hollow. I think when you really look at the evidence, when the Brendamores the Brendamores didn't want anybody to build on this lot. The Tuttles knew it. That's why they had them sign this agreement saying, look, if it's otherwise illegal, sure, you can argue this setback, but otherwise you can't. So what did they do? They tried to argue that it was otherwise illegal through the most hollow of arguments, so that way they can always address the front line setback. And we know, remember, it's a matter of law now in this case. It's res judicata that the rear line setback and everything else complained of was not illegal. And the contract says, unless it's found illegal, unless we find that it's a violation of the Indian Hill Code, you can't collect.
And then other neighbors were also arguing about the front line.
Exactly. On the behest of the Brendamores. The Brendamores went to every one of their neighbors to call the front line setback illegal. They were the agents. You can't have other people argue your arguments if the court told you, or you know what I'm saying? Like, you can't get around. As an attorney, I can't go, if I see a car accident victim, I can't go up and give them my card. We all know that's unethical. I can't have my brother or my kid do it either. I can't have an agent of mine go do it, and that's exactly what the Brendamores did. They completely whipped up the whole neighborhood because they don't want these neighbors, I don't know why, but they don't want these people moving in. So they went and they got a
So they
petition.
said the house was too big for the lot. They
Well,
don't like
that's
how
what
big
they're
the house is.
saying. That was their opinion.
Okay.
But it wasn't violative of the Indian Hill Code. They just didn't like it. So they went to all their neighbors, and they got their neighbors to argue that it's an illegal lot due to front setback. And I'm saying that they got the neighbors to do it on their own behest because they knew as they started going, uh-oh, we're not allowed to do this. So they went and had proxy. You can't do it. I mean, you want to talk about good faith and fair dealing when you get into a contract. This is the exact opposite of good faith and fair dealing. We know that the reason why the Tuttles got into this argument is because they knew the Brendamores were going to give whoever got this property trouble. And they knew that the only thing that would stick would be the front setback. So they entered into this contract, and what they forecasted is exactly what came true. The Brendamores argued front line setback. They got everybody in the community to argue front line setback, and then they shifted and made every other argument in the book, which now rings hollow as we look back. And I understand there was a decision along the way. But when you throw enough crap at the wall over how many years this went on, right? I mean, we're talking $250,000 worth of attorney's fees just to try to build, or excuse me, expenses. I think some of that's from the builder or the architect. But I mean, that's a lot of money to fight to try to build on a piece of property that you purchased. Everybody has a constitutional right to build their property, and the Tuttles knew that the Brendamores were going to do this. They have a history of doing this. So that's where the contract comes in. I've never seen a contract say anything like this on a piece of property. Why was it there? Why did they add attorney's fees in? To punish the Brendamores for behaving like this. Remember, this is a motion to dismiss. There's been zero discovery done. And if you just rely on 2 points, which is the Brendamores weren't allowed, I say I'm out of time, the Brendamores were not allowed to argue frontline setback. If you accept that, which is in the contract, which is part of the complaint, and if you accept the fact that the Brendamores whipped up their neighbors to do what they couldn't do, and that my clients, the Cons, had to hire an attorney and argue against those people as well, well, that's enough. That's enough. But there's more information in the briefs too, of course.
And you still have your 3 minutes for rebuttal.
I have a question for you on rebuttal. I'll save it.
Thank you.
Okay.
Thank you, and good morning again. May it please the court. Mike Roberts on behalf of the Brendamores. I've had some tough mornings as well. I think that perhaps Mr. Maislin misspoke on a few things because of his tough morning. And I'll start with what's simple and discreet, things that are in their complaint and attached to their complaint to address your first line of inquiry. At page 8 of our primary brief, I explain in objective detail the lack of objection. 2 weeks after Con filed their application, Brendamores wrote to the Planning Commission and said, quote, "We are not objecting at this time to inadequate lot frontage." So the premise that we heard this morning is the Brendamores started arguing inadequate lot frontage, ran into a roadblock, and then switched horses to talk about rear lot line. Not true. Not true based on their allegations of their complaint. Then, at the hearing that occurred, testimony from Doug Brendamore in March of 2017. When asked, he said, "We are not objecting to the fact that the Cons don't have adequate frontage." These are in their answer and counterclaim, which is trial document 32. 2 months later, another Planning Commission hearing, another letter. May 23, 2017. The Brendamores were not objecting to lot frontage. At the hearing, they say the same. So it's unmistakable that the Brendamores unequivocally, repeatedly said we're not objecting to lot frontage, period. Now, let's get back to why all of these cases exist. In 2003, Indian Hill wanted to correct their error. I think it's Exhibit 6 to the complaint, the Burns letter. Mr. Burns, longtime city manager, highly regarded, writes a letter to Hamilton County Auditor, I believe, and says, "We should have never allowed these lots to be created." So that's a mistake that was made by Indian Hill back in the 1940s. 2002, things occur at the property, and this issue is then comes to fruition that this mistake was made. So to help Indian Hill correct its error, the Brandamores paid $262,000 to acquire that property. This gets a little complicated. That's 2002, 2003. In 1977, this Holly Hill lot had frontage on Holly Hill. Holly Hill used to be an easement, became a public street. Once it became a public street, they had frontage. 25 years later, 2002, 2003, this easement existed. So the Brandamore said, okay, Indian Hill, we'll help you fix your error for $262,000, but this easement out to Park Road has to go away. It can't exist anymore. Indian Hill says fine. Tuttle says fine, because Tuttle's using Holly Hill. That's the lot frontage. So Tuttle then says, well, if I don't have access to Park Road anymore, that easement goes away, and all I have is Holly Hill lot frontage, you're not allowed to claim that there's inadequate lot frontage over there. Brandamore says, fine, we won't do that. As long as, to your point, as long as you comply with the other code. So in any event, in 2003, rights to Park Road go away. The Brandamores paid $262,000, and one huge condition of doing that was making that go away. And whether it occurred 13 years later, like it did, or whether it occurred the next day is really arbitrary. 13 years later, John West says, Cons, you cannot build this home on this lot with Holly Hill as lot frontage because it doesn't fit. The home was so massive that with Holly Hill as lot frontage, you have a problem with the rear lot line, the rear yard line setback. So John West says unequivocally, 2015, 2016, 2017, this house can't exist on this lot with Holly Hill as lot frontage. So John West says, hey, there used to be an easement over to Park Road. Let's claim that your frontage is way over there on Park Road. That's like saying frontage for this courthouse is at the banks. It doesn't exist. So whether that occurred 13 years after 2003 or the next day is irrelevant. That's arbitrary, the period of time. So it's effectively, Brandamore say, here's $262,000. We don't want this Park Road easement anymore. The next day, because it's arbitrary whether it's 13 years or the next day, Indian Hill says, hey, Cons, let's use this Park Road easement to build this house that doesn't fit for Holly Hill. That's lack of good faith. Again, I've been with Ms. Maislin's position before, but his arguments that that the Brandamores were arguing inadequate lot frontage and then went to rear lot line, totally untrue. The Brandamores were saying, you can't use Park Road. That was the argument for the first 6 months. In the hearing in March of 2017, the hearing in May of 2017, until the June 28, 2017 findings of fact and conclusions of law come out, when Indian Hill says, yeah, you can't do Park Road. That was the fight. That was it. So that's the entire period of time. We have a city council hearing, August 28, 2017. Fran Barrett, the best lawyer down for this, is arguing for Dr. Crambuel about lot frontage. Totally independent of the Brandamores. Totally independent.
Well, there's an argument that they're the ones that put them up to it.
Well, there should be a photograph of that house. If you could do computer-generated photograph and put the Kahn house behind Dr. Crambuel's home, her fantastic home where she's lived for 5 decades, to suggest that Dr. Crambuel only complained about that house being planted in her backyard because the Brandamores put it up is crazy. But the conspiracy claim is gone. Dr. Crambuel is gone. They dismissed those claims. They dismissed her. They have this assertion, but it's not, you have to read that in light of the Brandamores continuously. We are not arguing about inadequate lot frontage.
I think it goes beyond just the conspiracy claim, though.
How so?
I mean, as Mr. Maislin was arguing, if the neighbors were complaining about the frontage on the Brandamores' behalf, that goes beyond conspiracy. I mean, that goes to an agency argument.
Well, there's no evidence of that. I realize that they allege that in the complaint.
It's a motion to dismiss at this point.
Correct. But the contract that the Brandamores have it's not like a guarantee or indemnity or some kind of promise that nobody else with an interest. Dr. Crambuel had an interest. You had the property on the other side of the Holly Hill lot. But also, to your point, Your Honor, the Brandamores the agreement allowed them to argue inadequate lot frontage if there's something else wrong with the lot. And throughout that entire time, they were claiming Park Road, which is not legal. You didn't have access to Park Road. So during that entire time, even if you accept as true, which I don't think it is, but even if you accept as true that Brandamores put up somebody else with an interest to complain about inadequate lot frontage, the plan had a problem because it was based on Park Road. The complaint doesn't allege that the Brandamores argued inadequate lot frontage after August 28, 2017. It doesn't allege that. It says it stopped then. So during that period of time, Park Road, the attempt to put this property, the house on this property, using Park Road as lot frontage, that triggered everything. That triggered everything. And that's what the Brandamores were fighting. So that was the other non-conformance with the code that would have allowed the Brandamores could have said, listen, coming into the Planning Commission meeting, City Council, we object to lot frontage and we object to using Park Road. And that would have been fine. And that was the case from the start through June 28th. There was one hearing, August 28th. They say that the Brandamores argued inadequate lot frontage on August 28th. They don't provide the transcript of that. But Dr. Cranbrook was there arguing inadequate lot frontage. And I don't think that agreement can be read to make the Brandamores responsible for attorney's fees they incur to fight Dr. Cranbrook, who had an interest.
So at some point, the plans changed from Park Road being the front
At the August,
to the Holly Hill being the front.
Right, prior to the administrative appeal being filed, there were three hearings. One in March, one in May, one in August. March, May, they were arguing Park Road. June, it's decided it can't be Park Road. There was an August 28 hearing, 2017, with Dr. Cranbrook arguing inadequate lot frontage, independent of the Brandamores continuing to say, we're not saying anything about inadequate lot frontage.
But then the Brandamores switched to the rear line after that.
Yeah. Well, no. So they were arguing you can't have Park Road. You can't have Park Road.
And then they said, okay, we're not going to do Park Road.
And then it became, if you're not doing Park Road, then what John West has repeatedly said time and time again, the house can't exist with Holly Hill as lot frontage.
Yeah, but your client couldn't argue that.
We didn't.
What did your client do at that point when they said, we're going to use Holly Hill?
If you use Holly Hill, you run into the John West problem. John West said you couldn't do that because you have a rear lot line problem. It has nothing to do with inadequate lot frontage. It has nothing to do with inadequate lot frontage. Even if they had 1,000 feet of frontage on Holly Hill, if you use Holly Hill, you got a rear lot line problem. It has nothing to do with inadequate lot frontage.
Okay. So when they decided to use Holly Hill, your clients started arguing the rear line.
Because John West has said repeatedly that you can't do that. And quite frankly, Anita Birding wrote a pretty compelling decision that you can't do it either. Now, this court heard the decision that reversed Judge Birding's decision. Right. I think if this court heard Judge Birding's decision, you would have agreed with her based on the standard of review that applied to it. But she gave a very reasoned decision. I forget what year it has been.
Well, wasn't that overturned though? I mean,
that's
kind of doesn't. I mean,
it was. Yeah.
Okay.
Let me ask you, Mr. Robertson. This was a question I was going to ask Mr. Maislin. I'll give you a chance to prepare your answer. I'm looking at what I'll just call Brandamore 1, and the focus of that, at least from the Brandamore's perspective, was dealing with the rear line. What was the rear line? Was it opposite? What generally means, et cetera. But I'm noting that Dr. Cranbrook is the one that was arguing the lot frontage requirements. So I don't see anything in that earlier decision indicating at all that the Brandamores argued inadequate lot frontage. We focused on Dr. Cranbrook, at least that was her assignment of error. Is that a fair statement?
I think if you reviewed everything that was filed in the case, you wouldn't find one time where the Brandamore said inadequate lot frontage. It was always Cranbrook. It was always Brandamore rear lot line. I think all the judges along the way did a good job of saying, okay, the Brandamore argument is rear lot line, the Cranbrook argument is inadequate lot frontage. They're just, the two streams didn't cross.
And you are at your time if you, I'm not going to count, I'm not going to count into your 5 minutes for the questions that you responded to, but you'll have 5 minutes.
Thank you.
May it please the court. Scott Phillips on behalf of the Village of Indian Hill. This feels to me like the legal equivalent of Groundhog Day. I feel like we keep coming back to the same arguments, the same issues, despite rulings that have been made consistently throughout this process. So this is a breach of contract case in almost 30 years of doing zoning and land use issues. I've never seen anyone try to, in essence, turn a contract into a zoning case. But I give counsel for the Brendan Moores credit for coming up with an extremely creative argument. However, now that we have a decision from this court with respect to the zoning decision, which basically found that the village operated and made a decision that was consistent with the zoning code, their arguments collapse. It's interesting. We filed a motion to dismiss in this case. The reason we filed the motion to dismiss was based on the allegations of the breach of contract and the complaint that was filed against the village. And paragraphs 126 and 127 of that complaint provide the basis for the breach of contract claims. Paragraph 126, by knowingly approving the inaccurate lot line rear and rear yard setback and authorizing a plan that ignored the Brendan Moore's right to challenge variance requests, the village breached the 2003 agreement. 127, in addition, and this next clause is key, for these same reasons, the village breached its duty of good faith and fair dealing, which is contained in the 2003 agreement. So as we went through the process below on the breach of contract, that's what we were focusing on. That's what the arguments were. By the time that case was heard by the motion was heard by the Common Pleas Court, this court had affirmed the Common Pleas Court with respect to the zoning and found that the zoning had been handled correctly by the village, that their decision was consistent with the zoning code. The judge enters the decision based on what's in the complaint. It's notice pleading, so obviously looks at it and says, this contract, 2003, it required the village to only do a few things. We paid $150,000 towards the purchase of this property to put it into our green space program. The village has thousands and thousands of acres that it acquires or is given to it by residents in order to create green space throughout the village. It's part of what makes it a special place. So it wasn't unusual for the village in a situation like this to acquire property. The thought or allegation that it was somehow to correct a mistake is not based in reality. The village does this all the time. The evidence that somehow the village made this big mistake on these lots comes from a letter that was written by the previous city manager. When this case came through the process, those allegations were raised that this is an illegal lot, that this lot doesn't conform with the zoning code, that there had been a mistake made. And in the zoning case, before the Planning Commission and Council, there was a specific determination made by both entities that the lot was a legal lot, that it could be developed. And that decision, the decision with respect to some mistake having been made a long time ago, that was not appealed. The only two issues that were appealed was the front yard setback and the rear yard setback. So as a matter of law, this idea, the kind of the underpinning of this brand new theory that has been advanced by the Brendan Moores, that somehow there was a breach of good faith and fair dealing as it relates to this contract because there had been a mistake made, any of that stuff, as a matter of law, I think is barred because it wasn't appealed. By the time we get to the brief here, we have a new argument that hadn't been raised before. And this argument goes, as far as I understand it, and I'll admit that I have trouble following it, that because the village failed to record an extinguishment of this easement that related to the road, that somehow we violated our duty of good faith and fair dealing. Now, there's numerous problems with that argument. The primary one of which is the contract doesn't require us, doesn't imply, doesn't in any way put an obligation on the village to have recorded this. It's silent as to that. And
What did it obligate the village to do?
we had to do a title search. We had to have a survey prepared. We paid $150,000. We planted some trees. That's it. There was no obligation for us to record this. And frankly, the idea that this was some sort of material term that could now lead to us being embroiled in 5 years' worth of litigation over this is somewhat fanciful, in my opinion, because if it was such a big deal, if it was so important, if it was so critical, why didn't the Brenda Moores record it themselves sometime from 2003 till today? Or why didn't they bring it to anyone's attention before now?
Did they know it wasn't recorded?
Oh, they certainly could have found out if it was that
What if they
critical.
assumed the village was going to do it?
Well, I guess you could assume anything that you want to, but again, we're dealing with a contract, not basically some sort of assumption. There was nothing in the contract that affirmatively required the village to do that. So the idea that somehow we've now taken on an obligation that's led to a breach of good faith and fair dealing is a real stretch, in my opinion. The other thing, the idea that somehow there was this big mistake made and that because the extinguishment wasn't reported, that led to the Cons buying a lot that they otherwise would not have bought is disingenuous. The bottom line here is all the things that you've heard Mr. Roberts talk about, John West said this, or John West did that, or Mr. Burns did that, those men, great guys, very good at their jobs, are not the decision makers in this process. They are the staff. They gather information. They review the information. They make recommendations to the Planning Commission. And while it was true that with respect to this very odd-shaped lot, 8 sides, looks like a Z, it's not something that gets dealt with on a regular basis. It also involved frontage being oriented towards Park Road because that's traditionally where it had been oriented because of this easement. It's true that as they started analyzing that, they took the position, this is historically how this lot has been oriented. In the interim, since the last time back in the 70s that there had been any approval related to this lot, Park was the only legal, that easement was the only legal way for people to get in there, other than an easement on Holly Hill. Holly Hill had traditionally been used as the way people got in, but it wasn't recognized because it wasn't on a street. Holly Hill was an easement all in of itself. At some point in time, after Planning Commission had made this initial decision how to orient the house back in the 70s, Holly Hill was dedicated as a public street. Now it can be legally oriented towards Holly Hill. And so all this information is being gathered in the process. It's a public type process where everyone can be involved. They can send letters. They can talk to people. That all happens. This is the sausage making part of zoning. So it's not unusual for there to be initial preliminary thinking as to how something will happen. But that's all it is. It's preliminary. It's not final. The final is made by the Planning Commission. And by the time it gets to the Planning Commission, the body that has the authority to make these decisions, the only body, because Mr. West or Mr. Burns cannot make decisions as it relates to zoning. Only the Planning Commission council can. By the time it gets to Planning Commission, the Brenda Morse has raised this issue. It's been reviewed. The process has worked. There's been a determination that, yes, they have a point as to how the house should be oriented. The fact that Mr. West, years before that, had made a preliminary decision, which is not binding, that the house wouldn't fit there is completely and totally irrelevant. What matters is basically what the Planning Commission did. So the Planning Commission reviews it, orients the house towards Holly Hill based on the information they got, specifically says that the orientation is being changed from Park to Holly Hill because they had to make that decision at some point in time. It gets oriented that way. They determine that the front yard and rear yard setbacks for the way the house's design works. They find that this is a legal lot. And it goes to council, council affirms, goes to the Court of Common Pleas, Court of Common Pleas affirms, comes to this court affirms. This is a zoning case. The zoning aspect of this has been determined by the courts to have been properly done. And this contract case is nothing more than an attempted second bite at the apple. It's a collateral attack on a decision that's already been affirmed by this court. And as a result, the court should affirm the dismissal. There's a second claim in the complaint that was dismissed, the deed reformation. I don't believe it was briefed. Our position all along has been we can't reform a deed that we're not a party to. And therefore, if they want to reform the deed, they need to bring that claim with the current deed holder, which are the cons. So unless the court has any other questions, I'll rest on the briefs and the argument. Thank you.
Thank you. Mr. Mason, you have 3 minutes rebuttal.
Judge Winkle, let me first address your question, which is the Brendermores are intelligent people. When they went in to argue, well, first of all, at the first hearing in the Indian Hill Planning Commission, the two plans were submitted. One had a Park Hill address, the other one had a Holly Hill address. It's the exact same plan. You'll find when you read the transcript of what Mr. Brendamore was saying on cross is, okay, so are you arguing whether it's a Park Hill or Holly Hill lot? Yes, I am. Okay, well, if we don't use the Park Hill and you use the Holly Hill lot, well, you can't do that because then you don't have the proper front line setback. And you'll see my argument is they want it both ways, and you kind of heard it just now today, right? Even after they came back with, okay, well, we're going to use this address instead of this address. Oh, well, then we got to go back to the 70s because then there's not enough front line setback. The other thing I want to point out is when we talk about agency, this isn't just the Brendamores, okay? Or excuse me, this isn't just the Crambles. The Brendamores went and got a petition from everyone. Who drafted the language of that petition? The Brendamores. So the idea that the Brendamores aren't creating this whole crap storm so that nobody can build on this property and they're throwing everything they got at it is exactly what the Tuttles knew they would do. And that's exactly why they had a contract in place that says you can't do that. And then they even changed the contract at the last minute to say not only can't you do that, but if you do, you get punished. We can see this coming. You get punished, you have to pay the fees that are related to it. And that's exactly what happened. And there's a lot of double speak when you read through the record, right? I mean, the Brendamores are intelligent people. They know what they're contracted to do. They argue everything. And then when they get caught and they can't argue frontline setback anymore, right? Then they say, oh, they literally argue frontline setback, and then in the same paragraph say, but we're not arguing frontline setback. That's just the other people that we got to do it. And again, it's a motion to dismiss. At least let us take a couple depositions and ferret this out. If the complaint has a colorable claim, which if you agree with everything that it says, that the plaintiff's entitled to relief, then that overcomes the motion to dismiss. This isn't a motion for summary judgment. At least let me go and take the statements. Let me go prove to the court that that petition was actually drafted by the Brendamores. Let me prove to the court that the agency is true, that the Crambles were whipped up by the Brendamores. And it wasn't just the Crambles. There's like 20 people that came to that hearing. There's 20 people that are on that petition. And I'm making up that number because I don't have it in front of me. And with that, if there's any other questions? Okay.
Thank
All
you.
right. Thank you, Your Honors. And again, I apologize for my tardiness.
Oh, I think we switched the case up on you, though, so you weren't late. It was, no problem. You have 5 minutes.
Thank you. And none of that is surreply, so I'll rest on my briefs to ask the court to affirm the decision dismissing the con claim. The first argument that Mr. Phillips made is that the court should find a way to read paragraphs 125, 126, and 127 in a way that he claims it should be read. 125 incorporates all of the allegations that precede it. I think that Mr. Phillips while his reading is understandable, I don't think it's a fair reading given Rule 12. And paragraph 125 incorporates all the prior allegations, those prior allegations being paragraph 54, Indian Hill neglected to properly record the deeds. Paragraphs 55 through 61.
Counsel, where in the contract does it say that Indian Hill had to record the deeds?
You know, it doesn't say Indian Hill had to record the deeds. The only reference in the contract to the deed, this release of the easement, is in that one sentence on, I think it's section 11, closing.
Okay, I'm looking at that section.
Yeah, and it's about 10 or 12 lines down, and there's in the far left-hand column, there's a middle sentence that says fee and transfer tax, period. The next sentence is the only reference to what happens with this deed. Now, it says that Indian Hill is responsible for the preparation, we're paying for the preparation of it, but it's the only reference in the entire contract to that deed and what happens kind of at closing procedurally. Now, that gets into the good faith argument, meaning good faith is inherently, by definition, an implied undertaking.
But if they didn't breach the terms of the contract, how could they be acting in bad faith? I mean, the contract does not require Indian Hill to record that deed.
Again, Your Honor, if you bear with me 1 second.
Okay.
It's the only reference to the process of the deed. All of the parties understood and expected, their reasonable expectation was that Indian Hill would go forward, not only preparing it, and as they did, you know, their counsel's office prepared it, their counsel's office recorded it. Everything regarding the process of that deed, the parties understood would be taken care of by Indian Hill. And that's what happened. And that's why we have to deal with the good faith. That's why the whole contract argument is based on breach of good faith.
Because otherwise, who would record it? If they were doing all the preparation, right?
They were doing everything, really. That's what they did.
Right.
That's
I mean,
what the parties understood
it's
they were
strange
doing.
that that's not included in the contract, but at the same time, you wonder who else would do that.
Right. And so, you know, our law is massive, and our law includes good faith.
Now,
And
Mr.
good
Phillips, let me ask you this. I'm sorry. Mr. Roberts, let me ask you. Mr. Phillips indicated that of all these people involved in this 2003 contract, the one with the greatest interest in recording the abandonment of that easement would have been the Brendamores. I mean, who else other than the Brendamores had an interest in that? I mean, the easement went up across their land. It was an old abandoned driveway. So can you answer that? Who of all the people would have had the greatest interest in recording this, the abandonment of that easement?
I think they all did. I mean, yes. I mean, your question is kind of a rhetorical question.
Yeah.
It's a statement, right? I mean,
Right.
of course,
Yeah.
it's their property. They wanted to get this
Right.
released. Of course they did. So,
Right.
yes, they had an interest. But all the parties to the contract wanted the contract performed. And the only reference to the process of this put the obligation on Indian Hill. Now, put the obligation of preparing it and paying for it. But the parties expected for Indian Hill to do it, and they did it. And they did it improperly. And so, the case authority that I cite regarding good faith, it's an implied undertaking not to take opportunistic advantage, not contemplated, not resolved. It wasn't resolved. The point. No, it doesn't say who does the recording. It's faithfulness to an agreed common purpose and consistency with justified expectations. Well, the expectations were clear. Indian Hill was assigned to do it, at least processing it. So that was the expectation of the party. Parties were, in good faith, parties are required to use good faith to fill the gap of a silent contract. So this fits on Rule 12 exactly within the case law of good faith. Good faith duty depends on language of the contract, which leads to evaluation of reasonable expectations of the parties. And finally, the duty of good faith depends on language, and silence on an issue requires a trial. So the fact that it's silent about whose duty it was to do the recording requires a trial to determine what the parties' expectations were. So for that reason, and I don't know where I am on time, got a red light here.
You're at your time.
Okay, thank you. Again, we'd ask the court to affirm the decision on the con claim and reverse as to Indian Hill. Thank you.
Thank you. Thank you all for your arguments this morning. We will take this case under submission and issue a timely decision.
Thank you. Court of Appeals versus
Okay.
These chairs are so heavy.
Yes. I had my right on the one that was fine. I was fine.